Hi, my name is Raphael. I'm with AAPI Go. I'm the Director of Public Policy. And in matters of public policy, today we're going to be discussing the landmark Supreme Court case decision or opinion in NYSRPA v. Bruen, which is close to home for me since I reside in New York State. We're going to be going over what this ruling means, along with some of the aspects that you might not have seen on the mainstream media or even some gun media, because I think that it's more of a legal, more of a thing for a legal mind to notice than the actual gun part of the case, which is relatively minor. Let's get into it. So Justice Thomas wrote this. It's his birthday today. Happy 74th. You absolute legend. So, uh, these guys wanted concealed carry permits. They asked for them. The state said no. So they sued. And it made it all the way to the Supreme Court, who graciously decided to take it up. So we start with Justice Thomas going into the facts of the case. Because the state of New York issues public carry licenses only when an applicant demonstrates a special need for self-defense, we conclude that the state's licensing regime violates the Constitution. New York State has regulated the public carry of handguns at least since the early 20th century. In 1905, New York made it a misdemeanor for anyone over the age of 16 to have or carry concealed upon his person in any city or village of New York any pistol, revolver, or other firearm without a written license issued to him by a police magistrate. In 1911, New York's Sullivan Law expanded the state's criminal prohibition to the possession of all handguns, concealed or otherwise, without a government-issued license. So New York State sucks. You have to possess... Yeah, here we go. A licensed applicant who wants to possess a firearm at home or in his place of business must convince a licensing officer, usually a judge or law enforcement officer, that among other things he is of good moral character, has no history of crime or mental illness, and that no good cause exists for the denial of the license. Now, I don't know about you, but to me this sounds more like an excuse to be racist, because it's completely up to the issuing officer. Now, maybe that officer just really doesn't like people who are paler than me. Or hell, maybe I'm too tan, and I don't think so. But it all depends. Does that licensing officer feel good? Maybe his wife insulted him that morning. Maybe his wife told him he was a fat, ugly bitch. Because he probably is, let's be honest. And maybe that licensing officer is just, not feeling it. Maybe his vasectomy gave him an infection and his nuts are so big they hang down his leg. Maybe. I don't know. But either way, it's up to the licensing officer. And if he says no, too bad, you're out of luck, sweetheart. So obviously, the 6-member majority of the court took issue with this. They don't like that very much. They don't think it's very fair that one person gets to decide whether or not the Second Amendment applies to you. When a licensing officer denies an application, judicial review is limited. New York courts defer to an officer's application of the proper cause standard unless it is arbitrary and capricious. Now, proper cause is not defined in law anywhere in New York. It's pretty much, hey, licensing officer, are you a racist? Cool. Now, go get out there and deny some handgun permits. New York State sucks, by the way. I just want to make that clear. I'm not intending to be here for long, but let's keep going, because this isn't a long decision, but Supreme Court decisions are usually long. I mean, look at these citations. Come in there, but they're really long. So they're listing some states. There's only 6 of them that have may issue licensing laws. Aside from New York, California, DC, Hawaii, Maryland, Massachusetts, and New Jersey, all of which are bad places to own guns. All these proper cause analogs have been upheld by the Court of Appeals, except for DC's, which has been permanently enjoined since 2017. I don't know why DC gets special treatment. Maybe it has something to do with him not being a state. I don't know. So, we're still in the weeds here. We got to get to the meat. So these guys didn't really have any special specific danger. One of them lived in a bad neighborhood. The other one wanted it for self-protection. They were both denied. And these absolute lovely gentlemen decided to exercise their rights and sue the government for a redress of grievances. And boy, did they get it. They were why the case was decided the way it was, why they actually got certiorari. So in Heller and MacDonald, we held that the Second and 14th Amendments protected individual right to keep and bear arms for self-defense. In doing so, we held unconstitutional 2 laws that prohibited the possession and use of handguns in the home. Now, we get to the part of this decision that's probably going to have the most impact. And I'm not talking about the actual opinion itself. I'm talking about a sidebar almost. It's a side note to the main act. But this is more impactful to firearm law than any other court decision in the last decade. Here's why. In the years since, the Court of Appeals have coalesced around a 2-step framework for analyzing Second Amendment challenges that combines history with means-end scrutiny. So, intermediate scrutiny, strict scrutiny, those are means-end scrutiny. The government has an end. What's the justifiable means? If the government has a justifiable end, their means are probably okay. That's what means-end scrutiny means. And in the case of an absolute right, that's not okay. Imagine if the amendment prohibiting slavery was subject to means-end scrutiny. The government's like, well, we really want soldiers. And the court's like, well, you have a justifiable reason. I guess you can have slaves. And that's what means-end scrutiny means. It's not a good thing in the context of an absolute right. It's a bad thing. Today, we decline to adopt that 2-part approach. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. And they'll go on to apply that standard. But essentially, what this means is, under the court's interpretation of the Second Amendment, if the Second Amendment says you can do it, you can do it. Now, the court reads the Second Amendment to mean self-defense. Your right to keep and carry small arms in self-defense. I don't know about you, but that sounds pretty good to me. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. Only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. So basically, if we've been doing it since the beginning, or since early on, or if it's not that big a deal, and it doesn't, conflict with the fundamental right to keep and bear arms, you can do it. Otherwise, eat grass. Since Heller and MacDonald, the 2-step test that courts of appeals have developed to assess Second Amendment claims proceeds as follows. At the first step, the government may justify its regulation by establishing that the challenged law regulates activity falling outside the scope of the right as originally understood. Now, this is what they're taking issue with. This is the problematic process. This is the process that the Supreme Court says is not okay, is wrong, and should not be the standard as applied to an absolute right. A right that you have as a human being, not as an American citizen, as a human being, to keep and bear arms for self-defense. So this is the problematic opinion of the appeals courts, who obviously don't know what they're talking about. They're not Supreme Courts. Their robes are cheaper. They don't get the fancy chairs. They get the medium fancy chairs. And most of all, they don't get hate on every single media and social media platform for any move they make from both sides. So basically, they can't understand. I'm being semi-serious here. They actually can't understand. But let's keep going. The Court of Appeals then they ascertain the original scope of the right based on its historical meaning. If the government can prove that the regulated conduct falls beyond the amendment's original scope, then the analysis can stop there. The regulated activity is categorically unprotected. But if the historical evidence at this step is inconclusive or suggests that the regulated activity is not categorically unprotected, the courts generally proceed to step 2. At the second step, courts often analyze how close the law comes to the core of the Second Amendment right and the severity of the law's burden on that right. The Court of Appeals generally maintained the core Second Amendment right is limited to self-defense in the home. But see other case, where the amendment's core generally covers carrying in public for self-defense. If a core Second Amendment right is burdened, courts apply strict scrutiny and ask whether the government can prove that the law is narrowly tailored to achieve a compelling government interest. Therein lies the problem. If the government's like, well, we really want to, and we can give you a good reason why, the court can say, well, I guess the Second Amendment isn't that big of a deal. Or, I guess the 14th Amendment isn't that big of a deal. Or I guess the 19th Amendment isn't that big of a deal. And they'll just be like, you know what? Slavery is fine. But obviously that's problematic because the right to not be enslaved, unless you did something bad and have to go to prison for it, is enshrined in the Constitution. And I don't know about you, but that amendment sounds pretty absolute to me. Otherwise, they apply intermediate scrutiny and consider whether the government can show that the regulation is substantially related to the achievement of an important government interest. So, if they can't find that it's related to a compelling government interest, like one that the government feels compelled to act upon, it's okay if they find it important. They can just be like, well, it's a big deal to us. We really care about this. It's my son's birthday. Can you please give this to us? And they'll be like, oh, okay. Would you like a suckle on the zipple? You can have this. Both respondents and the United States largely agree with this consensus, arguing that intermediate scrutiny is appropriate when text and history are unclear and attempting to delineate the scope of the right. Now we get into the fun, sassy part. Despite the popularity of this two-step approach, it is one step too many. Step 1 of the predominant framework is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text as informed by history. But Heller and McDonald do not support applying means-end scrutiny in the Second Amendment context. Instead, the government must affirmatively prove. The burden of proof is upon the government to prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. So basically, can you fit it anywhere into this historical context, which is extremely limited? No? Have a good day, sir. To show why Heller does not support applying means-end scrutiny, we first summarize Heller's methodological approach to the Second Amendment. So we're going into the text of Heller. This is not that big of a deal. This is explanation for the opinion, which is important, but not what we're here about. So we're gonna go ahead and get down here. Constitutional text. All right. The dissent asserts that we misread Heller to eschew means-end scrutiny because Heller mentioned that DC's handgun ban would fail constitutional muster, but Heller's passing observation. So now in defense of their Second Amendment standard. This Second Amendment standard accords with how we protect other constitutional rights. Take, for instance, the freedom of speech in the First Amendment, to which Heller repeatedly compared the right to keep and bear arms. In that context, when the government restricts speech, the government bears the burden of proving the constitutionality of its actions. So it must explain why it's allowed to do this. If the government wants to restrict your speech, they have to have a damn good reason. And the same should apply to the Second Amendment. And finally, thanks to a Supreme Court that respects the ideals behind the Constitution, not even the Constitution, what the Constitution means. They respect it. They actually have an understanding that it has a meaning. It's not a tool to achieve an ends. It is the basis of the country. And it is one of the finest documents ever created by man. Now, what that means is that if the government wants to violate the Constitution, they have to have a really good reason, or even fit something edgewise in between some of those amendments. Fit a little wedge in there. they have to have a really, really good reason and explain how the Constitution may have allowed for this. Because, there are variances in the Constitution. When we outlawed slavery, we realized that, being in prison, a thing that every culture has always or nearly always had, being in prison can be construed as slavery. So we were like, well, unless you're serving time for a crime which you were duly convicted of, and then you're allowed to be enslaved. Now, there's still problems with that. I think it's far too broad, and there's a lot of issues with how that amendment is, interpreted. But the spirit of it stands, and that's what I'm getting at here, is that the spirit of the Constitution is carrying forward. The framers had just fought a treasonous war against a bunch of British people, and they were like, yeah, I might have to do it again. And that's why, that's the ideal behind it. It's pretty much a bunch of rednecks saying, yeah, we want guns in case we have to do this again. So we go through some, essentially not boilerplate, but some pretty standard legal writing comparing the First Amendment to the Second Amendment and how they're defended and why they're, incontrovertible human rights. If the last decade of Second Amendment litigation has taught this court anything, it's that federal courts tasked with making such difficult empirical judgments regarding firearms regulations under the banner of intermediate scrutiny often defer to the determinations of legislatures. But the Supreme Court is special, better than you, and understands things, so we don't have to do that. That's not actually in the text. I'm being facetious, but federal courts tend to defer to legislatures, especially on matters of firearms. And the Supreme Court says, no, they don't have to defer to legislatures unless the legislatures pass constitutional amendments. The Supreme Court's job is to interpret the Constitution and the legality of laws passed by legislatures against that Constitution. And that's what the rest of the federal courts should be doing too, but half the time they don't bother. So the test that we set forth in Heller and apply today requires courts to assess whether modern firearms regulations are consistent with the Second Amendment's text and historical understanding. In some cases, that inquiry will be fairly straightforward. For instance, when a challenged regulation addresses a general societal problem that has persisted since the 18th century, the lack of a distinctly similar historical regulation addressing that problem is relevant evidence that the challenged regulation is inconsistent with the Second Amendment. Likewise, if earlier generations addressed the societal problem but did so through materially different means, that could also be evidence that a modern regulation is unconstitutional. And if some jurisdictions actually attempted to enact analogous regulations during this time frame, but those proposals were rejected on constitutional grounds, that rejection surely would provide some probative evidence of unconstitutionality. So probative evidence is not like incontrovertible evidence. It's, this speaks to this pretty well. So a lot of this is leaning on Heller, which is pretty settled case law at this point and has been, it is the law of the land. So basically in Heller, a DC police officer was banned from having a handgun at home due to DC's overly restrictive laws. And the Supreme Court was like, no, you get to have guns at home. That's allowed. You can have firearms in common use at home. And the state has to provide a mechanism for you to do so. So this is kind of expanding on Heller, because Heller kind of covered the keep part of the Second Amendment. So keep and bear arms. This is covering the bear part of the Second Amendment. So keep and bear arms. So in Heller, 2008, the court established, writ large, that the Second Amendment protected the individual right to keep arms in the home. Now, this is simply an expansion, explaining that the Second Amendment covers the right to carry arms outside the home. So, comparing New York's law to Heller, which makes sense. It's materially similar, and that's completely understandable. While the historical analogies here and in Heller are relatively simple to draw, other cases implicating unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. The regulatory challenges posed by firearms today are not always the same as those that preoccupied the founders in 1791 or the Reconstruction generation in 1868. Fortunately, the founders created a constitution and a Second Amendment. intended to endure for ages to come and consequently to be adapted to the various crises of human affairs. Although its meaning is fixed according to the understandings of those who ratify it, the Constitution can and must apply to circumstances beyond those the founders specifically anticipated. See cases where see a case where we decided that a tracking device is still, it's still covered by the Fourth Amendment, the right against unreasonable search and seizure. So we're going through more legalese here. We covered the amazing part, which is the new test. Let's skip ahead to the conclusion. Okay, maybe it's a little less short than I thought, but still skipping ahead. All right, now we're at the end. The constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. We know of no other constitutional right that an individual may exercise only after demonstrating to government officials some special need. That is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. That is not how the Sixth Amendment works when it comes to a defendant's right to confront the witnesses against him. And it is not how the Second Amendment works when it comes to public carry for self-defense. New York's proper cause requirement violates the 14th Amendment in that it prevents law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms. We therefore reverse the judgment of the Court of Appeals and remand the case for further proceedings consistent with this opinion. It is so ordered. And now you know why this case is one of the landmark cases. Not only does it establish, may issue as unconstitutional, and shall issue, that is, if you meet the legal qualifications to own a firearm, you will be granted a concealed carry license. Not only does it do that, but it establishes a new framework for all firearms cases going forward, in which courts are not allowed to decide if the government's compelling interest is good enough to prevent you, the citizen, from having your basic rights infringed upon. But now the court must decide. Am I going to read the Second Amendment and apply it as written and historically understood? Or am I going to enable tyrannical, anti-human rights laws that restrict normal human beings from exercising an inborn right by virtue of being a human that we should all be able to enjoy? And that, frankly, is the most exciting part of this decision to me. It's not going to change much in New York. At least not at first. New York will simply delay, make it as difficult as possible to apply, and otherwise show that they have no intention of respecting the ideals behind the Second Amendment. All they want is control. But the Supreme Court just opened the floodgates for every single good citizen who wants to sue New York State for infringing upon their rights. And that's the real meat of this decision. Really hope you found this informational or at least entertaining. Please leave a like, maybe even subscribe, leave a comment. Tell us how you feel. Tell us if you have anything else you want answered. As you see right here, I have a concurring opinion, which I think I'll be going into next week because there is some sass, there is some fire, and it's pretty funny. So Samuel Alito can get pretty sassy, and we always like to see that. So yeah, again, please leave a like, subscribe, comment. We really appreciate it. We're working as hard as we can to get as much content out as possible, and we're hoping to do more analysis style videos like this. So if this appealed to you, share it around. Hopefully it's a good explanation of what this court case actually means and means to you. Thanks, and have a great day.